Good evening and welcome to the lecture series for the preparation of CLAT examination 2023. In this lecture series, we are discussing about the important provisions or the legislations which has been created and which is being used in the law fraternity for the better implementation of the society. And these law subjects takes an important ground in your preparation for a CLAT examination, because these questions have been asked numerous times. These legislations has been asked numerous times in our CLAT competitive examination. The legal reasoning portion of your syllabus, as you all know, that the CLAT has been divided into five major areas, where which first is English, second being logical reasoning, third being the legal reasoning, where which we are dealing with the same. Then it obviously is the general knowledge is there, and then you have quantitative aptitude. In our previous lecture series, we have discussed about law of contracts, which has provided us with the information that what are the documents or what are the essentials which are needed if somebody wants to be in an agreement, or when somebody wants to come to an agreement in regards to uh, formation of a contract. So we have discussed about the essentials. We have discussed about how the contract is formed. We have discussed about what are the exceptions, and we have discussed about how a contract, if not followed, what will be the consequences of the same. We have discussed about void and voidable contracts. So majority of the things that has importance in regards to preparation for CLAT examinations has already been talked about in that particular lecture series. If you wish to see that, you can obviously utilize our resources to get to those videos, which it will be very much helpful for you. After that, we have started with the criminal law. In that criminal law, we have discussed about what exactly are the offenses that is there. We are actually discussing it. Prior to this, we have talked about the general exceptions that are there. In the general exceptions, we have talked about how a person, even if the act reveals or it is prominent to see that the act is nothing but an offense, but still the person, the wrongdoer, can claim relief because it is falling under any of the exceptions that has been mentioned under the provisions of the law. The provisions which deals with the criminal law and provides us with the definition of the offenses of the different offenses that are there is Indian Penal Code 1860. This, if you are able to see the screen, the provision which we were discussing in our previous lecture was culpable homicide, which is an offense which is affecting the human body. In order to help you and understand, I will just quickly show you the whole Bare Act. This particular PDF is the Bare Act of the legislation, that is the Indian Penal Code, as I've just informed you. And this Indian Penal Code is the provision which is going to provide you the detailed summary. This provision is going to provide you the detailed summary of the offenses for which one can be punished. We have talked about actus reus and mens rea, which is an important requisite to constitute a crime. And after that, we have talked about what are the exceptions. If you can see the screen, we have talked about chapter 1, which we have discussed about what exactly is the preamble, and what is the title, what is punishment of offenses committed within India, after punishment for offenses committed beyond India. We have discussed about extension of extraterritorial offenses. We have discussed about certain laws not to be affected by the act. Then general explanation is something that is self-explanatory. We need not go further and in depth in regards to the same. We have talked about what exactly is punishments, how many types of punishments are there. We have talked, and After that, the most important provision, or if I would say the important chapter that is very much helpful, that will be very much helpful for you while you're preparing for the examination. And it is also expected for any of the person who is studying law, should whenever there is an offense that takes place, one has to take into consideration these general exceptions in order to formulate whether the person should be held accused for the commission of an offense or not. The reason for the statement is just in front of you, there is a definition which is clearly showing you that the definitions in the code here, if we say the definitions, what we are talking about the definitions of the offenses. So the Bare Act itself, the law, the Bare Act, or the source of law. In regards to criminal law, if we see correctly, this particular section 6, which says the definition in the code is to be understood subject to the exceptions. And if we go and see and delve with what exactly this particular section is saying, and it will be much beneficial for you if we can see that in front of us. And just let me scroll down there for your better understanding. Okay, yes. This section 6, what it is saying that the definition in the code to be understood subject to exceptions. Throughout this code, every definition of an offense, every penal provision, you're getting my point? Every definition of an offense. So whenever there is a definition of an offense, means in section 302, you will find mention of murder. So the definition of murder is under which section? It is under section 302. So the definitions of offense, every penal provision. So there will be provisions. Okay, this is one paragraph, this is one provision, then you have another paragraph, this is second provision, the third paragraph, this is third provision. Okay, and every illustration. These illustrations also, whenever there will be a section where, whenever there will be a definition, in order to make the person understand that what exactly the law wants, the legislator wants to convey is, for better understanding every sections, majority of the sections, you will find mention of illustrations. So the illustrations help you in understanding the concept in a clearer manner. So that is why it is very important, at least for the CLAT aspirants, to understand the illustrations as such. Because the questions that you will be getting in the form of factual questions, these questions will actually be confined towards these illustrations only. So once you're getting a thorough knowledge of what these illustrations are saying, you can utilize that knowledge in order to solve the questions. When we will be discussing the definitions in this particular lecture series, in this particular session also, we will be focusing ourselves towards the illustrations more, because these illustrations will provide us with the guideline as to what exactly will be the scenario or what will be the outcome if particular act happens. Okay, so what this particular section is saying, that whenever we are going to read the definitions, whenever we are going to read the penal provisions, all these definitions and penal provisions has to be read. All these definitions of penal provisions shall be understood subject to the exceptions contained in the title, chapter title, General Exceptions. Though these exceptions are not repealed in such definitions, penal provisions, or illustrations. Okay, so repeated in such definitions, penal provisions, or illustration, because see, it would have been very difficult for the legislator to explain that, okay, this will be the exception in this particular matter. So in order to provide a clearer picture of what the law wants to reveal, or what law wants to convey, the legislators, what they did was that they provided a separate chapter which is dedicated towards the general exceptions. And in those general exceptions, we have already discussed those general exceptions. Our focus is, according to section 6, and this is something which is the law is saying. It is not me who is saying. It is something which nobody can deny the fact, because it is something which has already been there in the form of law. So the law says that the definition in the code is to be understood subject to exceptions. So whenever we will be studying the definitions of the different offenses, the offenses, why we need to understand the offenses, the reason being, once we have understood that what particular act will constitute an offense, you will be able to understand and distinguish that whether a particular offense has been committed or another offense has been committed. For instance, for a better understanding, I'm giving an example. If somebody has used a stick and has beaten another person to that extent that the person was hospitalized for a total period of 1 month and his life was endangered. So what are the different offenses that the particular person who has beaten the other person has committed? So in order to understand that what are the offenses that has been committed by the person, you should actually understand, or you should have knowledge of what exactly the definitions of the different offenses are conveying. Whether this particular act by the offender will be considered to be hurt, whether it will be considered to be grievous hurt, whether it will be considered as murder, or whether it will be considered as attempt to murder, or whether the person who has been accused of this act can use the general exceptions to showcase to the court that he has not done anything wrong or contrary, which will save him from any of the accusations that is there. So it becomes very necessary, it becomes very important for all the aspirants to understand that every sections, every definitions that we are going to read shall be subjected to the general exceptions as such. And why I'm emphasizing over the general exceptions, the reason being the questions that will be there in your CLAT examinations will be focused over these exceptions and the illustrations of this particular act. So I've just conveyed it to you. Let's see the illustrations for a better understanding. This section in the code, which contains definitions of the offenses, do not express that child under 7 years of age cannot commit such offenses. But the definitions are to be understood subject to the general exceptions, which provides that nothing shall be an offense which is done by a child under 7 years of age. Now let's take an example that hypothetically a boy who is of 6 years of age was playing with a gun which was loaded. Okay, there's a real gun. And accidentally, he pulled the trigger, the bullet shot somebody and the person died. Now, according to the definitions, if we'll go and understand section 302, murder, it says that if there has been an act and that act is constituted with a guilty mind, then it will be considered to be a crime. Actus reus plus mens res equals to crime. But here is an exception that has already been mentioned under the general exceptions, and that is that if there is any person if there is an act that has been done by a child who is below 7 years of age, and in our instance, in our example, the child is of 6 years of age. So specifically shows that the child is incapable of understanding the situation, and since it has been covered under the general exceptions, the child shall not be held liable for the act that has been committed. So that is why the general exceptions, as we have already discussed, if you have any doubt in that, you can just refer to our previous videos where which we have in detail understood what exactly are the exceptions and what are the relevant exceptions that we need to keep in mind whenever we are going forward for the preparation of this examination. So after this general exceptions, understanding of the general exceptions, we will be focusing our mind towards those areas which we have to understand the definitions of the different acts that constitutes a crime. We have already discussed these points here. We have discussed about the general exceptions. Now we were focusing our mind over the definitions of the different crimes or the offenses that is there. Okay. We have talked about criminal conspiracy. We have talked about sedition. Now we were focusing over the offenses which is affecting the human body. When we talk about offenses affecting the human body means that any offense or any act which is illegal in nature according to the Indian Penal Code, IPC 1860, and the essential ingredients of that particular offense as mentioned in the definition is being fulfilled, that particular person who has been accused of committing that particular act will be considered as the offender of that particular crime that has been committed. Okay. So here in this particular chapter 16, let me clear things for you so that it can be. So we will be starting with offenses against the human body. And after the offenses against the human body, we will be studying about offenses against property. And then we will be studying about general offenses which are there. We'll be studying about defamations. We will be studying about nuisance. We will be studying about mischief. And then we will be studying about some other offenses which are of importance when we talk about CLAT examinations as such. So when we start with the chapter of offenses affecting the human body, the first and the foremost thing that we need to understand in this chapter is that the offenses affecting life. So there is human body. And then when we talk about human body, then there is life. So any offense which is going to affect the life of the human being, that particular offenses has been defined under this chapter. The first and the foremost section 299. So I have just informed you in our previous lecture series that the total offenses that has been mentioned, or the total provisions or the total sections that has been mentioned in this IPC is there are 511 sections. So out of those 511 sections, you have to be focused over some important sections, because there are chances that the questions will be as such that obviously there are chances, the chances are very less, but we have to make sure that our preparations is as such that even if the examiner is asking us that under which section of the Indian Penal Code this particular offense has been mentioned, so we can at least recall that under this particular section the particular offense has been mentioned. For instance, under section 299, culpable homicide is mentioned. Now, when we say culpable homicide, what do we understand by culpable homicide? When we say culpable homicide, we are talking about culpable homicide. Now, homi and side. Homi means human and side means killing. And culpable, voluntary. So voluntary human killing is nothing but culpable homicide. Now when we talk about culpable homicide, you must be getting a confusion that, sir, whether culpable homicide is an offense or not. Yes, exactly. Culpable homicide is also considered as an offense, and there is a very thin line between an offense which is called culpable homicide and which is an offense which is called murder. So we need to understand and we need to distinguish and we need to get a clear idea that what offenses will be considered as culpable homicide and what offenses will be considered as murder. So if we try to understand that what exactly is the major difference, I would like to reiterate it to you in the form of a diagram so that it will be easier for you to understand. So if we say that there is culpable homicide. So let's take an example that this is culpable homicide. Okay, this is culpable homicide. And when we say murder, so murder is a small portion of culpable homicide. Obviously, murder is considered to be graver than culpable homicide, reason being it is more heinous. Because when we say murder, what we are saying is that there has been killing of human. Yes, so homicide is there, and killing of human plus there was intention to kill the person. So intention to kill the person. Majority of the time what the student gets confused is that the culpable homicide is an entirely different offense and murder is an entirely different offense. What we need to understand is that culpable homicide and murder is correlatable, and perhaps culpable homicide can be considered as the genus and murder to be the species, because culpable homicide is providing us a detailed explanation that what exactly can be constituted as a voluntary human killing, and murder is defining us that what exact acts of kill shall constitute murder. So in order to understand, let's go through the definition. So once we have clearly understood the definitions and the illustration is also clear to us, it will be very much easy for you to tackle those questions, because there is 100% chance that you might get question from this particular topic of culpable homicide and murder. So whenever we talk about culpable homicide, what we say is that whosoever causes death. So if there is a person who causes death by what? By doing an act. By doing an act with the intention of causing death. So if there is an act with the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge. So their first requisite is with the intention of causing death. This is the first requisite. Okay, this is the first requisite. With the intention of causing such bodily injury as to likely to cause death. This is the second requisite or the second condition. Or with the knowledge that he is likely by such an act cause death, commits the offense of culpable homicide. So there are three things that one needs to take into consideration. First is that there should be intention. I have the intention to kill somebody. This particularly can be considered as murder. Second is with the intention of causing bodily injury as to likely to cause death. Now, if I have, this is bodily injury, right? Yes, bodily injury which is likely to cause death. Yes. So bodily injury which is likely to cause death, and the third one being knowledge that he is likely by such an act to cause death, commits the offense of culpable homicide. Now take this for a particular example. A lays sticks and turf over a pit with the intention of thereby causing death, or with the knowledge that the death is likely to be caused. Z, believing the ground to be firm, treads on it, falls in and is killed. A has committed the offenses of culpable homicide. So now, whenever there is an intention to kill someone, okay, that my acts will obviously be killing some human being. That act, if I have the knowledge or the intention, knowledge and intention both are different. Okay, we need to understand that. When we talk intention, we are saying that our act has been done in order to get that particular goal or motive. But when we say knowledge, we know that once we do that act, it will obviously result in a particular thing to be done. Or if we talk about culpable homicide, with the knowledge that death will be caused. So if we have the intention to cause the death, or if we have the knowledge that our act by all probability is going to cause the death, we will be considered that we have committed culpable homicide. Now, what exactly will be the difference between murder and culpable homicide then? If you can see the illustration that is mentioned there, A lays sticks and turf over a pit with the intention of thereby causing death, or with the knowledge that the death is likely to be thereby caused. Z, believing the ground to be firm, treads on it, falls in it, and is killed. A has committed the offense of culpable homicide. So here if you can see that although A had the knowledge and the intention of causing death, but he had not taken into consideration that whose death is going to be caused. So what he did, he created a turf in a pit and he covered it with sticks, and another person, a bystander, passed through it and he intentionally fell into it and he died. For example, you must have seen on highways you have potholes. If the potholes is not covered, okay, and the person, the worker who has the knowledge that if the pot is not covered, there are high chances that somebody might fall in it and he might die. And he, knowing that particular thing, doesn't covers it, and somebody falls and dies, then although that particular person has not murdered somebody, because when we talk about murder, we have a specific inclination towards a particular person. So this is the major difference between murder on one side and culpable homicide on the other side. Culpable homicide says human killing. So in human killing, what we are suggesting is that no matter whether we intended to murder a particular person or not, if somebody has been murdered, it will be considered as culpable homicide. But when we talk about murder, on the other hand, murder is specifically towards a particular person. So this is the major difference between culpable homicide and murder. Culpable homicide means killing of a human being. It is not there that the person should have the intention to kill that same person in culpable homicide. But when you talk about murder, the important requisite is that the act or the intention of your particular act should be towards a particular person only. A lays sticks and turf over a pit with the intention of thereby causing death of X. Okay, causing death of X only. Okay, or here in this example it is Z. So let's take Z. So now if the act of A was with the intention of causing death of Z, and thereby because of that particular act, Z dies as of the consequences of the same, then the person, obviously he will be held liable for section 300 also for culpable homicide. But apart from that, he will also be held liable for murder, which is a graver offense, because he had the intention to kill Z only, and by his act he has murdered Z. So this is the difference that you need to understand: culpable homicide and murder. Murder specifically towards the person to whom the murder has the killing of the person is done is for the specific person, and when the act is as of such a nature that we have the knowledge that we are going to commit we are going to kill somebody. No, although we are not sure to whom we are going to kill, but if the killing is done, then it is considered as culpable homicide. Another example, you must have seen in marriages that there is a person obviously who's carrying a gun who wants to fire, and when he fires, he shoots and the bullet goes and hits somebody, although that person never had the intention of killing the person. So whether that person should be freed or he should not be charged for an act? Yes, obviously he will be charged, because although he has not murdered a particular person, but although he has committed culpable homicide, he has killed somebody. And why we have considered that it is being killed? Because the act, he knew that particular fact, that if I'm going to fire bullet open in the air, and there are high chances that that particular bullet is going to hit back to some particular person, and there are the chances that the person might die. And if that particular act has been done from that particular person, he will be held liable. So this is the main difference between culpable homicide and murder. A knows Z to be behind a bush. Okay, A knows Z to be behind the bush. B does not know it. Okay, B does not know it. There is a bush. Okay, and there is A who is standing there, and Z is behind the bush. Okay, Z is behind the bush. A intending to cause, or knowing it that likely to cause Z's death. Okay, Z's death induces B to fire at the bush. B fires and kills Z. Here B may not be guilty of any offense. Okay, here B is not guilty of any offense. The reason being that he was not knowing that there was somebody present behind the bush. Okay, he was not present. He was not knowing that there was somebody present behind the bush. But A knew. Okay, A knew. A has committed the offenses of culpable homicide. Now your question should be that whether this particular act of A is only culpable homicide, or it can be murder also. The answer is it will not be murder, because the particular act was not done by the offender A, but rather it can be considered as abatement to murder. Abatement to murder. We have discussed abatement. We have discussed what exactly is abatement. And if you are confused, you can obviously refer to the previous videos so that you can get a better idea that what exactly is abatement. So rather that person will be held liable for murder, abatement to murder, but not murder. The reason being, as I told you, that the act between the difference between murder and culpable homicide is that the act particularly should be done by the person who has been accused of murder. Okay, had this been the scenario that in this particular illustration, instead of B, A would have fired, and in the consequence Z would have died, then A would have only not be held responsible for culpable homicide, but also for murder. I suppose the things are clear to you. What is the difference between culpable homicide and murder? Okay. Now this is what the definition of murder says. For a better understanding, let's go through and understand this particular point. Except in the cases hereinafter accepted, culpable homicide is murder if the act by which that is caused is done with the intention of causing death. Okay. If it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of a person to whom the harm has been caused. Okay. So what is this particular definition is saying? It is saying except in the cases hereinafter accepted. Accepted means there is an exception. Culpable homicide is murder. So what he is saying that majority of the times culpable homicide shall be considered as murder if the act by which death is caused is done with intention. That is what we've discussed in our when we were discussing about culpable homicide and murder, that there should be intention, and based on those intention, that should be caused. So intention, when we say intention, what does that mean? That means mens rea. And when we say death has been caused, so means the actus reus is also there. So mens rea plus actus reus will constitute what? It will constitute crime. So what crime we are talking about? We are talking about murder as such. But if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause a death of the person to whom it is caused, or if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in ordinary course of nature to cause death, or if the person committing the act knows that it is so immensely dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, or commits such act without the excuse for incurring the risk of causing death as aforesaid. Okay, so these are the areas where which the person shall be held liable for murder. Okay, the first point is intention plus act. This is first point. Now second point is bodily injury which is likely to cause death. Third, which is causing bodily injury, inflicting bodily injury sufficient to cause death. And then you have fourth, which is saying act imminently dangerous. Okay, so these are the illustrations. You are supposed to go through the illustrations for a better understanding. It will help you to clear your confusion as to what exactly can be considered as a culpable homicide and what exactly can be considered as murder. These exceptions needs to be understood in a very clear manner. A shoots Z with the intention of killing him. So A shoots Z. Simple. A is there. He shoots Z with the intention of killing him. Z dies in consequence. A has committed murder. There's a simple explanation, simple example you must have understood. A, knowing that Z is laboring under such a disease that a blow is likely to cause his death. I knew that there is one person who is having some injuries where which if any even if a small hurt is going to cause his death, and me with that knowledge and with the intention of killing that person hits that particular person in that particular area, because of which the person dies, I have committed murder. Okay. A intentionally gives Z a sword wound or a club wound sufficient to cause the death of a man in ordinary course of nature. Z dies in consequence. Here, A is guilty of murder, although he may not have intended to cause Z's death. Okay, so now there are chances that whenever there is a heated argument, and you must have seen that people take out weapons and they start arguing violently, and in that particular act there are sometimes chances that the person might have inflicted injuries. And why is it so important that why is it so that we have clearly understood that if we have murdered somebody, if the person has died and we have the intention, then why is it so that we need to get to those complexions? The reason for that is there are chances that even if the act would have committed a sword cut or a club wound sufficient to cause the death of a man. Let's take this example in such a manner that A fires at B. Okay, so everybody knows that if I fire somebody, if A fires fires at B, and because of that B dies in consequence, then it is pretty much clear that the death is going to be caused. Okay, but and A also had the intention. Here, if A, even if without intending to cause Z's death, A didn't have the intention to cause death, but what he did, he shot at Z from point blank range. So this is self-explanatory that if somebody shoots at someone from point blank range, there are high chances that the person will die. And taking into that consideration, it is important that even if the intention was not there at that point of time, but shooting the act as such, the would have got the knowledge that my particular act is by every means possible is going to cause the death of Z. And still, if A has shot Z, then even though if the intention is not there, but since the knowledge is there, the person shall be held liable for murder. So what we got an idea from this particular illustration is that either intention plus act will constitute murder, or knowledge that act leads to killing and plus still doing that act, then the person shall be held liable for murder. If the intention and the act has been done on same person. Yes, so the same person is there and the act has been done. A, without any excuse, fire a loaded cannon into the crowd of a person, kills one of them. A is guilty of murder, although he may not have the premeditated design to kill any particular individual. So what we got to understood here is that if we don't have the intention, but we have the knowledge that our act is going to kill somebody, then it is 99.99% murder. But if we don't have the intention, neither we had the knowledge. Okay, if we don't have the intention, neither we have the knowledge, but our act has caused death of a person, then that particular act will be considered as culpable homicide, which is not amounting to murder. So if we divide culpable homicide, then culpable homicide, that is human killing, can be divided into two portions. First being murder and second being not murder. Okay, so these are the two differentiations or two bifurcations of culpable homicide. This is the first thing I just inform you when culpable homicide is not murder. Culpable homicide is not murder if the offender, while deprived of his power of self-control by grave and sudden provocation, causes the death. So first is grave and sudden provocation. So if there is a grave and sudden provocation, means that somebody has instigated you, that you out of anger, you have committed that particular act that causes the death of a person who gave the provocation or causes the death of any other person by mistake or accident, then that person shall not be accountable for murder. Why? Because the intention was created by the victim itself. So here, general exception, the exception for this particular point where which a culpable homicide, that is human killing, shall not be considered as murder if there is a grave and sudden provocation. Okay. And apart from this particular grave and sudden provocation, one needs to understand more clearly is that provocation should not be voluntary. So if let's take an example, I want to murder for somebody. What I did was I went to him, I started defaming him in front of public, and I knew that this particular person is a very short-tempered person and he will obviously act in such a manner that he will either assault me or he will try to hurt me. And knowing this fact, I took the advantage, and then when I killed that person, and when the court asked that why have I killed that person, I informed the court that there was a grave and sudden provocation that was given to me. The court will say that although there was a grave and sudden provocation that was there, but it was not involuntary. There was voluntarily provocation. You by yourself has done an act because of which the person provoked, and after that provocation you have killed that person. So that is not considered to be a ground for being a defense. If I'm instigating somebody, and because of that instigation, that particular person is trying to do an assault to me, or he is trying to hurt me, and in order to take that particular advantage, I killed that person, then it will not be considered as culpable homicide. It will be considered as murder. Reason being, it was my own approach. I initially instigated the person. After the person got instigated, and he started after losing his self-control, he started assaulting me, and then using that as a ground, as a defense, I killed that person. And now I'm claiming that because of grave and sudden provocation, I have killed that person because it was nothing but an act of self-defense. That cannot be claimed, because the law says that if the provocation is voluntarily, then that particular defense cannot be claimed. Second is that the provocation is not given by anything done in obedience of law, or by public servant in lawful exercise of the public servant. Take an example: police officials try to restrain you that you are not supposed to go to this particular place because of orders from the superiors, and you got furious and you murdered. Okay, and then you claim that he restrained me from going to that particular area, and that was I lost my self-control, and because of grave and sudden provocation, I killed that particular person. You cannot do it, because the exception says, that particular law says, that if there is anything which is being done in the obedience of law, it cannot be used as a defense. Okay. Then the third is that the provocation is not given by anything done in a lawful exercise of the right of private defense. Private defense, we have already studied our general exceptions, that whenever there is a private defense that is happening, then we are not murdering somebody. Okay, we are not murdering somebody. It can be considered as culpable homicide, but then obviously the court will see to it, the merits of the cases, that whether this particular act should be considered as a culpable homicide, or it should be considered as an accident itself. So this is an exception of when the culpable homicide shall not be considered as murder. And if these things are present, that even if the person claims that I was under grave and sudden provocation, that even if there is a grave and sudden provocation, but these three requisites are present, then also the person will be held liable for murder. You're getting my point? That although there is an exception that if there is murder will not be constituted, culpable homicide will not be considered to be murder if there is a grave and sudden provocation. But even if there is a grave and sudden provocation, but that grave and sudden provocation is because of the three requisites, which is right in front of your screen. First one being voluntary, second being by the public official, the third one being by the act of private defense. And if these three are present, then the person shall be held liable for murder, but not culpable homicide, because it is the exception of the exception. Yes. So this is what the candidate needs to understand. Now you see that there are lots of illustrations that is there. It is always suggested that you go through these illustrations, because once you have acquainted these illustrations. So this is first exception. Okay, that is grave and sudden provocation. Then the second exception, when the culpable homicide shall not be considered, is right to private defense, that I have already told you, not only of the person but of property. And this particular section, I suppose you have read in when we were talking about the general exceptions also. In the same way, it has been mentioned here. Culpable homicide is not murder if the offender being a public servant. Now, if this has been done by a public servant, then also it will not be considered as murder. Culpable homicide is not murder if it is committed without premeditation in a sudden fight in heat of passion. This is something which you can consider as grave and sudden provocation, like the same as grave and sudden provocation. Exception 5. Culpable homicide is not murder when the person whose death is caused, being above the age of 18 years, suffers death or takes the death with his own consent. With his own consent. This is very important. A. By instigation, voluntarily causes it a person under 18 years of age to commit suicide. Okay? To commit suicide. Here, on accounts of Z used, he was incapable of giving consent for his own death. A has therefore abated the murder. Okay? So, if the culpable homicide is not murder when the person whose death is caused, being above the age of 18 years, suffers death or takes the risk of death with his own consent. Okay. Now, this particular example, if you will see, is somehow relative to euthanasia. Euthanasia, you might have heard, euthanasia is something which is known as voluntarily dying. Now, if I am above 18 years of age and I give a consent, keep an apple. Okay, this is an apple, okay? And this is my head. And I ask my friend B that you shoot at me in such a manner that the apple should be destroyed. B constantly tells me that there are high chances that you might also die. And I voluntarily says to him that it's fine, you just fire, I am confident that I won't be killed, but rather the apple will be destroyed. B shoots, and because of that, I got shot. And result of what was, I died. So now, here B shall not be held for murder because he never had the intention. Although he might have knowledge that his act is going to cause the death. But here, what we need to understand is, since we are talking about the exceptions, that when the murder shall not be considered, culpable homicide shall not be considered as murder, we need to understand that if we have the knowledge and the act was not voluntarily, okay? So here what we see that there is one more requisite that is adding. One is intention, second was knowledge, third was the act. Now, apart from that, we have voluntary. So now voluntary act with the intention or the knowledge, if all these three requisites are present without presence of the exception that has been mentioned, then it shall be considered as murder. Understood? So that is something that you need to understand, because there will be a lot of questions that will be dealing with culpable homicide and murder as such in your papers. And that is very important for your CLAT examination, because this particular difference, the exceptions, you will be getting questions from these exceptions only, and the illustrations as such, if you people can understand and retain these illustrations, then any question that will be coming from culpable homicide and murder can be solved very easily by the CLAT aspirants. Okay. Now these sections are not relevant for you, so I won't be dealing in that. Dowry death, you might be given the principle. So first, what you need to understand is that the death of the woman is caused. This is very important. When we say dowry death, that is something which means that the death has been caused because of the demand of the dowry. And in regards to the demand of the dowry, the debt was caused. And that is why we have to see what are the requisites. So according to section 304B, 304B of what? Of Indian Penal Code, which talks about dowry death, the first requisite is that the woman should die. You cannot say that dowry that has been caused by if the person has maybe injured the wife until unless the wife is surviving. Okay, so there cannot be any death involved. The woman should have died. This is the first important thing. The reasons for the death should be burns, injuries, within 7 years of marriage, along with within 7 years of marriage, these injuries and burns were there, along with that remand for these injuries. The demand for these injuries was in relation to dowry. So dowry, injury, you can say burns, dowry demand plus burns and injuries plus within 7 years plus death will constitute what? Will constitute dowry. Is it clear? What is dowry? That has been mentioned under the Dowry Prohibition Act. You can just refer to that, but I suppose it's not important for you. Whoever commits dowry, that shall be punished with a imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life. So 7 years minimum punishment, maximum punishment imprisoned to life. Now, this is section 306, abatement to suicide. That is not relevant for you, but you need to just remember this, that when we talk about abatement to suicide, suicide should be done. If the person survives, no shall act be under section 306. That if the person survives, then there are chances that the person can be held for mental cruelty. It can be taken into consideration that hurt has been caused, but it will not be considered as abatement to suicide. Okay. Then you have attempt to murder. If you have done an act, but the person has survived, then you will be considered as an act which is known as attempt to murder. Okay, the punishment is also mentioned. I suppose this is clear to you. The rest of the things you need not study. That is not relevant for you. Neither you have to study causing miscarriage, and these things are not important as of now. Okay. Now, first we studied about affecting human life. Now we will be talking about hurt. Slapping somebody on the face, whether it is hurt, grievous hurt, attempt to murder, still a doubt? Once we will be acquainted with the definitions of what is hurt, what is grievous hurt, then all your doubts will be disposed of. So the first thing that we need to study here is that section 309 defines hurt. Whosoever causes bodily pain, bodily pain, disease or infirmity to any person is sought to cause hurt. If there is any disease that has been caused, okay, bodily injury has been caused, or infirmity to any person is caused, is said to be constituting as hurt. Now, if you see the definition of hurt, there is no mention of voluntary, involuntary, intentionally, or knowledge. What this presupposes is that if act has been done, it will by default constitute offense. So you might get again confused that, sir, here if the intention is not there, if intention is not present, then how we have considered as a crime? Yes, the reason being, when we talk about hurt, and we know that a particular act is going to cause bodily pain, disease, or infirmity. So we have this particular thing in mind, that this particular act is we have the knowledge. If I slap somebody, I know this fact that is going to hurt. Yes, it is going to pain. So if I knew this fact that it's going to pain and I still I slap that particular person, it is considered to be a hurt. If I'm suffering from a communicable disease, let's take an example of a fever, or maybe typhoid or pneumonia. And what I did is that, knowing this fact that I'm suffering, I intentionally went to somebody's house and I shared my food with him. And because of that, the person got disease. That also can be considered as hurt. So whenever you catch any disease because of your friend, you can always tell him that your act has hurt me, and I can pursue to the court to claim damages or to punish you for the same. Although the punishment is very small, so nobody goes there and take that particular matter in mind. But yes, you have the authority. You can even approach to the court in regard to the same. Okay, so now there is a very important discussion that we need to do, is the difference between hurt and grievous hurt. Hurt and grievous hurt, the major difference is the same things will be there. Body injury, bodily pain, disease, or infirmity will be there, is grievous. But when it includes emasculation, okay, emasculation means damage to your reproductive organs. Then you have permanent privation of the sight of eyes. If your eyes has been there is a permanent privation of the sight of the eye. If your sight has been blocked, if you are not able to see, now you have become blind because of somebody's act, it will be considered as grievous hurt. Privation of the hearing of either eye. Because of the slap, my right ear, I was unable to hear from my right ear because of the slap. Now immediately the act which was being considered as hurt has now been converted to grievous hurt. Now you see the difference. The difference is a very small, a very fine difference between, and it goes with every crime. So that is perhaps the reason whenever you will be studying law and when will you be studying about criminology, you will be getting an idea that there is a very small difference between an act which can be considered as a hurt, and then there is an act which will be considered as a grievous hurt, and then it can be considered as murder or attempt to murder. Because all the acts are connected in such a manner that whenever there is any offense that has been committed, it will obviously attract more than one definition of the offenses. Meaning which one person can be tried for different offenses mentioned under different sections under IPC, because all these sections are somehow, some way overlapping. Okay. Now, if that particular person has caused grievous hurt, I have slapped a person. My intention was not to kill that person. You just wanted to hurt the person. I slapped that person, and when I slapped, because of that, his left ear got privated, and now he is not able to hear it. So now he become deaf, blind and deaf, private or any member of joint. Okay, if I got fracture, okay, fracture or dislocation of bone or tooth or any joint. So if my ligament is fractured by the act of the offender, it will be considered as grievous hurt. So you see that there are different things that, as you mentioned, destruction or permanent impairing of the powers of any members of joint. Okay, so if the group of joints that are there, let's take example of elbow, let's take the example of wrist. There are different joints that are combined together, and if there is a permanent impairing or destruction of these areas, then it will be considered as grievous hurt. Okay. And eighth, any person who is endangers life and suffers to the during the space of 20 years is severe bodily injury. If somebody has suffered for a continuous period of 20 days severe bodily injury because of an act that has been done, it will be considered to be grievous hurt. Okay, so these are the 8 requisites which one needs to remember, that if these 8 requisites are present, then hurt gets transformed into, this is hurt, this gets transformed into grievous hurt. I suppose the things are now a little bit clearer to you. So hurt and grievous hurt provides you, the definitions has been provided under section 319 and 320, and the punishment has been mentioned under section 323 and 325 respectively. So all you need to do is you need to just go through the section and read the section so that you can get an idea that what shall be the punishment. Okay, the description which may extend to 7 years and shall also be liable to fine. So the maximum punishment for grievous hurt is 7 years plus fine. And when we talk about hurt, it can be extended to maximum of 1 year, and fine of 1,000 rupees or both. Is it clear? Yes. So now let's move forward and let's see what are the important other provisions that one has to go through. Yes. Now we are moving towards those areas. Here we have talked about hurt. We have talked about affecting the life. Now we will be talking about rights, where which the person as such is not going to be inflicted by any of the injuries, but still his rights will be confined or restricted. And the first example is wrongful restraint. The offenses affecting human body, first thing we studied about affecting life. After that we have studied of hurt. Then we are studying wrongful restraint and confinement. So when we say wrongful restraint and confinement, what we are trying to convey is that a person, since we know that we have some rights, and we will be studying those rights when we will be studying about constitution and when we are studying about the fundamental rights, obviously we will be dealing with those areas also. When we say these rights are there, so in that particular rights, there is one right that has been given to us, that is to move freely throughout the nation. So this is a fundamental right. If somebody tries to stop us from availing that right, he can be held liable for an offense, and that offense is wrongful restraint. If I wish to move to, let's take an example, I belong to Uttar Pradesh and I wish to move towards Himachal Pradesh. Okay, so from Uttar Pradesh, Himachal Pradesh is in the northern areas, northwestern to be precise, and I started moving in that particular direction. After a certain period of time, I've been stopped by some group of people, and they tell me that you cannot move particularly in this particular direction. Then that act of those persons from restraining me or restricting me from going in a particular direction shall be considered as wrongful restraint. Whoever voluntarily obstruct any person so as to prevent that person from proceeding in any direction in which that person has the right to proceed. Right to proceed. How did I get that right? I got this right from the fundamental rights under Article 19. That is, we'll be studying that, but first you need to understand what are the offenses that are there. Okay. The obstruction of a private way over land or water with a person in good faith believing himself to have the lawful right to obstruct has not an offense within meaning. Okay. So now read this one. Illustration. A obstruct a path along which Z has the right to pass. A not believing is in good faith that he has right to stop the path. Z thereby prevented from passing. A wrongfully restrains Z. I suppose this is self-explanatory. I did not explain you this. Now this is wrongful restraint. Wrongful restraint, one particular direction. And what is wrongful confinement? In all the directions if I've been confined. Confined means confining somebody in a particular limited space so that beyond that particular space he cannot move. That is wrongful confinement. Whoever wrongfully restrains any person in such a manner as to prevent that person from moving beyond a certain circumcising limits. House arrest, best example of wrongful confinement. We are expecting that their questions will be from wrongful confinement, taking into consideration the current affairs that has been in news, and there are lots of house arrests that has been taken place when there was matters of Article 370, abrogation of the special provisions of for the Jammu and Kashmir, J&K. So there were lots of house arrests that took place. So that is why there are high chances that you might get the questions from wrongful restraint or wrongful confinement in this exam of your CLAT preparation. Okay, rest you don't have to study, that is not important. You need just go superficially through what exactly is assault and battery. You just have to read it, it will be understand. Assault is a gesture that you're going to attack somebody or hurt somebody, but you are not actually hurting. If you're hurting that person, it will be considered as battery. Assault and battery comes hand by hand. Now abduction you must have listened that have been abducted. Whoever by force compels or any deceitful means induces any person to go from any place is said to abduct that person. Okay, abduction and kidnapping is different. Abduction means that you are by force compels, okay, or by deceitful means induces any person to go from any place so as to abduct that person. Okay, but kidnapping means it is from the lawful guardianship only. So kidnapping can only be for minors. If I will say I have been kidnapped, any person or from lawful guardian shall be punished with an imprisonment of either description which may term with extend to 7 years or this. Okay, so abduction, it can be for both kidnapping from India, kidnapping from outside India, kidnapping who come without the consent of that person or for some person legally authorized to consent on behalf of that person is said to kidnap that person. Okay, so if you are what you are doing is in kidnapping you are taking that person into your custody and you are taking that person out of his area, and rather from the custody of his guardian also, then that will be considered as kidnapping. But on the other hand, abduction specifically means that you are by deceitful means compels the person. Okay, compels. Here is the difference. Whoever by force compels means you are asking that person to move by himself. Or by deceitful means induces. Any person to go from any place and sets to abduct that person. Okay, so abduction and kidnapping are different. Abduction, it is by compelling, by talks, by deceitful means, but not by threatening or by injury or by hurt. But when you talk about kidnapping specifically, first it is from the guardian's hand, from the guardian, lawful guardian, and if it is beyond it, if the person is being taken out of the custody of the lawful guardian, then it will be considered as kidnapping. So kidnapping and abduction also needs to be understood, because it is very important for your competitive examinations, CLAT examinations point of view. But you need to just go through the understanding what exactly means definition of kidnapping and abduction. You need not study all the relevant cases there, that eventually you will be studying, and the difference between kidnapping and abduction needs to be understood. Okay, now what is trafficking? Trafficking is something which means exploitation, recruits, transports, harbor, transfers, receives a person by using of threat, using force, by abduction, by practicing fraud, by abuse of power, by inducement. So trafficking means transferring of one person, harboring of one person, recruited of one person. Okay, for anyone. You must have heard that majority of the sex slaves are being transferred or have been trafficked, human trafficked. If you would have seen the movie Gajni, so you would have seen that there was a scene where the actress was forced to, he was confined to a bogie in which there were majority of the girls who were being trafficked from one place to another, so that their kidney can be taken out and can be sold. So that is the best example for you to remember trafficking. Okay. Then I suppose these are not very important for you guys. Now, we have completed that particular point. We have left rape as such, because we have seen that there are never been questions being asked in regards to rape, because it is a complicated topic, and thorough knowledge of and understanding of that particular topic is needs to be there, and the CLAT aspirants are not supposed to understand that knowledge, not expected to have that knowledge in depth. But there is one point where which you need to understand that there will be questions in regards to theft and extortion and robbery and dacoity. So we need to understand what are the differences between theft, what is the difference between extortion, what is the difference between dacoity, and what is robbery. So first we need to understand what is theft. Theft had been mentioned under section 378 of IPC, and it specifically says whoever intending to take dishonestly any movable property. So the first requisite here is dishonestly, second is movable property, third is out of the possession of the owner. Okay, for your better understanding, I'm mentioning owner of any person without that person consent means the owner. Moves the property in order to such taking. Fourth is moves the property. Is said to commit theft. Okay, so these are the requisites. First is dishonestly, second is movable property, third is out of the possession of the owner, moves the property. The four things you need to remember. If I have taken a property, let's take example, this is my pen. Okay. My friend wants to take this pen. He comes to my house. He takes that pen in good faith, believing it that I have given him the consent to use my pen. He takes my pen, he uses my pen, and then he informs me that I had taken your pen from your premises. Now let's try to find out whether this particular act shall be considered as theft or not. The answer is no. It shall not be considered as theft because the person who might have taken that particular property out of my possession, being a movable property, and he moves the property for his own use, but his act was never dishonest because he had that particular thing in mind, that he is doing the act bona fidely because he has the consent of me, as he being my friend has my consent, and that is why he shall not be considered as to has committed theft. Another example, I have a house constructed, and what I do is that I try to take that house from the owner of that house in a deceitful manner. Can it be considered as theft? Answer is no. The reason being, house is something which is attached to the earth, which is not being movable, is not subject to theft until unless it is attached to the earth. Had the example taken being a tree which has been attached to earth, it is still been attached to earth, it cannot be considered that we have the theft of a tree has happened. But once the tree has been severed out of the earth and now somebody takes it out, takes that particular tree along with him, then you can consider it to be a theft because now it has been severed out. This is the explanation one, which I was just explaining you. So I need not to go further. Then the second thing is the moving effect by the same act which affects the severance may be a theft. Okay. Now there is a car. Okay. It is on an inclined platform. Let's take this one example for your better understanding. So this is the road, and now this is the plane, and this is the road. Okay. This is a hilly area. And then there is a car. Very good in drawing, guys. So kindly bear with me for the same. Okay. And now this particular car is being stopped by a small obstacle, and the person is resident here. Let's take example A. A is the resident on a hilly area. His car is parked in his area, and in order to stop his car from moving, he has used an obstacle. B wanted to take this car. So what he did, without the permission of A, dishonestly, he removed this obstacle so that the car should move in the direction, in this particular direction. So this particular act, even though he has not touched the object, but he has just removed an obstacle, this also can be considered as theft. There are questions which might be confusing when you will be seeing in the paper, because the explanations and the events are such that majority of the acts which if being read without knowing the law shall be considered, it cannot be considered as a theft. Removing an obstacle, can it be considered theft? Yes, it can be considered theft, because although we have not moved the property by ourselves, but by our act the property got moved, then also it will be considered as theft. This is explanation 3. A person is said to cause the thing to be moving by removing an obstacle which prevents it from moving, or by separating it from other thing, as well as by moving it. Okay. A person who by any means causing any animal to move is said to move that animal, and to move everything which in consequence of the said motion is moved by that animal. So theft, animal is also an object, maybe it's a being, but it can be considered as a property for humans. And once some particular animal is being moved from one place to another, let's take the example of cattle. You must have heard that there are cases where which people complained that my cow was stolen, my dog was stolen, my cat was stolen. So that taking out that particular animal from the possession of the owner with the guilty mind, moving the particular person, moving the particular animal in particular direction is considered to be theft. So these are the important requisites of theft. These are the points that you need to remember, and taking into consideration these requisites, you need to read these illustrations. Once you have read these illustrations, it will be pretty much clear for you that what exactly is considered to be theft. There are around 1, 2, 3, 4, 5, 6, 7, around 20 plus illustrations. If not 20, at least 15 illustrations are there. If you will study, you will understand theft. And trust me, this is the most important area for your CLAT examination, because the theft has majority of the illustrations, and from these illustrations you will be getting a questions directly. And once you have acquaintance with these illustrations, it will be a cakewalk for you to solve these questions. Yes, so this is what theft means. Then after theft, we have extortion. Extortion is an important, it is also being asked. Extortion is nothing but by putting somebody in fear or injury of that person or any other person, induces the person so fear to deliver any property. So in theft, what we were doing, we were by ourselves going and taking that property out from the possession of the owner. But here what we are doing is we are forcing the person by imminent danger, by putting the person into the fear of his life or some other person's life, and inducing the person to deliver a particular product or particular property to us. Then it is considered as extortion. You must have seen in the movies where which a villain calls the actor or some other person, and he asks that particular person to pay a ransom of 5 lakh rupees and 6 lakh rupees if he wants that his child should be saved and should not be killed. So this is something which is a clear example of extortion. I would recommend you to go through the illustrations for your better understanding, so that if the question comes in regards to extortion, you can directly understand what exactly has to be applied and whether this particular act can be considered as extortion or not. Now, robbery and dacoity. Now, when theft is robbery and when extortion is robbery. Okay, so robbery, what is robbery? First, we need to understand what is robbery. So, robbery is nothing. Robbery is an act of committing a theft. But when the theft is being committed, what we need to understand here is that the theft is along with the fear of injury. Theft along with the fear of injury when accompanied by a group of persons. Okay, what the important requisite is for robbery is that there should be at least 2 persons. Theft is robbery if in order to committing of the theft or committing the theft or in carrying away or attempting to carry away property obtained by the theft, the offender for that involuntary causes or attempt to cause to any person death, hurt or wrongful restraint or fear of instant death or imminent instant hurt or instant wrongful restraint. Meaning which during the commission of the act, during the theft, during the commission of the theft or before the commission of the theft or after the commission of the theft while taking the property, the wrongdoer, the offender puts the owner under the pretext of hurt, death, wrongful restraint or any of the offenses that has been mentioned here in this paragraph. then he is considered to be committed, he has committed robbery. So it is a very important requisite that you need to understand. And when we talk about extortion, so extortion, in the same way, in theft, what we were doing, in theft, it was the wrongdoer who is going to take out the possession. But in extortion, it is the owner who is going to provide the property to the wrongdoer by himself. Example could be, there is a burglary that happens in a house. So the person, what he does is, he enters into the house, he takes out the property, and while he was taking out the property, the owner got alarmed. He tried to stop, and at that point of time, the offender took out a gun and showed that gun to the owner, because of the pretext of being hurt and wrong, and because of that, because of chances of being killed, the person got feared and he moved away from the path. And after that, the person flew away. That is theft, when the robbery is considered to be theft. Now, another example is, the person entered into the house and he showed a gun to the owner and he asked that whatsoever property you have, you provide it to me. That is robbery, which is extortion. I suppose it is clear to you that what is the difference between when a theft is considered to be a robbery and when is extortion considered to be robbery. The illustrations are there, I've already mentioned. You can go through these illustrations, and once the illustration is being understood to you, you will be able to clear this particular thing in a very clear and sound manner. Now let's move towards what is dacoity. Dacoity is when 5 or more person conjointly commits or attempt to commit a robbery. So this is the only requisite that you people to remember, that when you talk about dacoity, it is a group of people which are 5 or more in number. So at least 5 people committing the same act of robbery, which has been mentioned up, will be dacoity. And what you need to remember, which is an important requisite for a CLAT examination, is that when you talk about dacoity, even the preparation, in the earlier time we studied that there are actually stages of crime, which is about preparation, then yes. So in the first stage, that is preparation only, dacoity can be held liable. The person who is involved in dacoity can be held liable. Yes, so dacoity and robbery are important point that you need to remember. Yes. So we have completed the majority of the portions which is regards to the Indian Penal Code. There are only 5 to 6 sections that are left. We have to talk about dishonest misappropriation of property. We need to talk about criminal breach of trust, and then we need to talk about defamation. So these 3 sections are left in our Indian Penal Code, and post completion of Indian Penal Code, we will be moving towards the Constitution of India, where which we will be studying about the main features of the Constitution. What are the fundamental rights? What is writs? What is fundamental duties? What is directive principle of state policy? How the parliament is formed? How the whole structure of the government is being formulated? What exactly is the preamble? And all these information will be very much helpful for you, because not only it will be helpful for your CLAT examination, but being the citizen of India, you should be well aware what are your rights and what are your obligations. When you can force the government to help you in a particular manner, and how to approach the court to get your rights reinstated. So with this, I would like to tell you that we are completing, this is the second last lecture of your Indian Penal Code, an important topic of your legal studies section for CLAT examination. Only 3 sections are left. We will be trying to complete those sections in our upcoming lecture. And post completion of that lecture, we will be starting with the Constitution of India. and that Constitution of India. We will be taking around 4 to 5 lectures to complete Constitution of India. We will try to summarize all the important requisites, and post that we will be focusing over the law of torts. After law of torts, we will be focusing over time and energy towards international law, and post that we will be focusing towards IPR, intellectual property rights. Once it is over, we will be moving forward with the case laws and the legal maxims that are there. I suppose you have understood the main concepts of what is culpable homicide, what is murder. We have understood what is theft and what is extortion. We have studied what is robbery, what is dacoity. We have studied about wrongful restraint and wrongful confinement. We have talked about kidnapping and abduction. And apart from that, we have studied about abatement of suicide, attempt to suicide, abatement, attempt to murder. So these are the very important sections that will come in handy for you whenever there will be question in regards to these particular topics. You are recommended to study the Bare Acts. Use these Bare Acts to study the criminal manual there, understand the definitions. And apart from that, you need to thoroughly read the illustrations. I'm focusing and I'm facing over this point because the illustrations will be helpful for you once you have completed you have understood the definition and you have understood the definition. Any point, any illustration will be used in a different manner. For example, if you can see the screen, this particular illustration has been mentioned. So when your CLAT paper will be there. So in your CLAT paper, instead of A, there will be a name Ram. Instead of Z, there will be name Shyam. And then there's the same question the same illustration will be put forward in front of you. And then there will be questions that under which provision of the Indian Penal Code, which crime has been committed. So that is why it becomes very essential for you to go through all the illustrations of the different sections that we have studied. You are not supposed to touch any of the sections that we have not touched, because that will be not at all reasonable to focus your time and energy over those sections which is not going to be there in paper. We have confined our syllabus in such a manner that only the important provisions of the different legislation that we are supposed to study should be taken into our consideration. And post completion of that, we will be starting with our after all the legislations has been completed and all the legal maxims and the case laws has been discussed, we will be starting with our mock tests, so that you people can also get acquainted that how the questions will be there and how you have to solve this. With this, I would like to end today's lecture, and we will be meeting in our next lecture, which we will be completing the remaining portions of Indian Penal Code, and we'll also be starting with the Constitution of India. Thank you so much, guys. Bye. Take care.